Yedikan, I think says any Okayan, Court of Appeal, the more judgment about the appeal. In as much as Ubia and also be in the Court of Appeal, no, I disagree. No, that remains a compelling judicial precedent. A court Kessie, we use Supreme Court, and if you are court, a Kessie, Tosubium, the Court of Appeal, as an High Court. It is only court in Yadrin Krana. That is the court na kan na mebo amande lawyer for court to timi references our decision here abey. Now eja mate say amanfo pie raise concerns. Me party MPP are raise concerns about the judgment. I think say primarily no, to start with, we cannot isolate the case of judgment in Abano. Any the political undertones are we cannot isolate the two. Even though say I agree say judgment need a solely judiciary and as a court of appeal in the judgment, but the two cases Sedinam Tamakloe said not a politician and you're prosecuting and you're convicting. Until you cannot isolate politics from judgment in Abano. But I think also say prosecution did their case. Prosecution presenting the case. Follow case now prosecution for 7 witnesses, including the head of finance for Maslock, including the general manager for Obatampa Investment, and a number of witnesses are prosecution no from. I think say prosecution need there or any case. Nemum, the most important conversation was a having a case the court etia Madam Sedinam Tamakloe. Yedikan. The prosecution allege say 500,000 Ghana cedis via Maslock. Say omo de koye investment ewo Obatampa Investment, you know. The Maslock chief executive officer at the time Madam Sedinam Tamakloe etro letter koma Obatampa Investment say omo ni omo terms no omo nji omo terms ni ntumi nti omo withdraw Maslock withdraw from the investment. Utie testimony in so general manager for Obatampa Investment in the buyer now. O say Madam Sedinam Tamakloe this a letter ne buyer. O demande say sika na nkomo de buy investment no. On fan brand back so also refund this can in cash. Now Madam Sedinam Tamakloe, according to the witness and the general manager for Obatampa Investment, no, man persistent and consistent pressure. So on sika ne brand no. Nti sika no omo withdraw ne cash. Eno diko shia maame no wo bacho na Total filling station. Eno de maame ne na onu kura na okukuru sika ne disi maame ne Land Cruiser boot. Ena maame ne de sika ne koy. That is what the witness said in cross examination. Now later no witness ne san ka say omu demanding receipt from maame ne to acknowledge say indeed ne nsa kan sika ne back. Maame ne ye receipt. Oye receipt no ena oye receipt na or sign receipt in so. That was with the Obatampa Investment. The second one had to do with Kantamanto fire victims Sikebia and Wasanke and also about 523,000 Ghana cedis or so. Say sometime in 2014, 2015 Kantamanto share and a president Chaska was a Maslock no. Ya de boa se be business and kete adwamfo makola fo ene ade inti president Cheska say yemfa nko boa omo a omo dwetire ahye. According to the prosecution no enkrofo a no mo ye intended say nko mo be benefit from say sika no anko na maame Sedinam Tamakloe divert sika no de kogu account bia na enye the intended account for the money. In the prosecution's understanding, no, sir, adhere no amounts to stealing, because in law, you can't say stealing. One of the essential elements also proving is say adhere no you be there, and I will no adhere no one fa kwan paso, and what depriving the pakrono of sadie no, and I say will be adhere you be there now what fasa adhere no, one fa kwan paso what fasa adhere no, a free the pakrono in some. Intimbrano a charge no for stealing. Say we are or my nisika of 500 and something thousand Ghana cedis. They told some yensa. Abani sound born kwadu say or my authorization for some 61.1 million Ghana cedis. Now, say authorization on my end, and for the necessary processes so. In no mind is to yemuno. Say dear no I amounted to causing financial loss to the state. If we say one ma in faswo amba sa or mine sika 61.1 million Ghana cedis no. Ejova, okay, same way ni aboma. Or mine born do for about 70 count. Okay, sikani ni abom 78 count. Okay, sikani ni aboma. Sikani ni amounted to about 90 million Ghana cedis. Prosecution as required by law. So now kind of led by Godfrey Dam. I think at that time no a deputy attorney general. The case no court prosecutor on the case. Now let's state it clearly. Say the prosecution doesn't have the power to convict anybody. All the prosecution can do is to present a case no to court. Prosecution no presenting the case not so we are defense no akonya say obe file an application for submission of no case. IHSF, the prosecution has not been able to prove their case beyond reasonable doubt. Into no court no ensure say my defense no kura no ombie nasem and asem mane embe church ono nso ni nsemu. Enti after prosecution ni close your case. In fact, before prosecution ni be close your case, Sedinam trial started sometime in 2019. Sometime in 2020, before prosecution ni be close the case no. And odeba court say ne ho fa no person okwa ma no ne no kwaje ayaresa. And that judge ne man ne kwan. Justice if you say wa botwe man ne kwan say onko no mbra. No man I think 2 months or say 1 month. That time now madam said nam Tamakloe no on bail. Okoye no wan babiem Alex mode in a standing surety. I think say no so be fine same P by any ade
but twene ko ekire kakra answer na obo ko abrochire no na ya tutu Sedinam Tamakloe anu ewia na wo court ana
in terms of say obey ye be cross examine o dey be say na make no say prosecution in the case and the be that time na prosecution ni gusu ye the case
no kra wo mbie ni case say ye be tutu na no mpo
there be and I even post
I just want to be sure I want to follow you.
I understand but what they can say and I even kra ni mbra mu no mbra bia nhye say accused person no obe mount witness box no. It is within accused person, right? Say opa mounted witness box, opa all mounted. One mounted witness box, no so am boning crow the friend examination in chief now. O prosecution no nyakwa cross examine. Ha. Intino time of prosecution here in the case na ma me say ne ho fa no 2 kwan. O 2 kwan no wantima mba biem. Ye nia ye nim de nti a wantima mba biem. And a prosecution ni closing the case. And a judge no order say defense ni bi o mo case. Defense ne so eye omo nsema cross examine witnesses na prosecution no from no. In fact before our witnesses ne defense ne be omo case ne say prosecution no the witnesses ne be more examination in chief defense no so wo ho kwan so no so be cross examine defense ne so yes an yama ni na madam Sedinam Tamakloe obi in the case ne ade na course wa the tintin in tietie mu an say sometime in 2024 court no convicted no say and was sentencing his uncle there fiase for 10 years. Court ne decision ne buy and the judgment ne buy and no finally appeal in that same 2024 because CI19 and even yambra na Ghana hanakana the law is say judgment ba na convict you be within 1 month say obe file notice of appeal and I say who intention say obe appeal I will say within 1 month no utimi ye onyomania ha intino or file appeal but from what we know any and statement the prosecutor at the time the deputy attorney general and the bar out no subsequently obey attorney general and the bar say omo file appeal no omo anya hwe and omo kodae after omo file appeal no because under ne penso no nothing came to his attention say madam Sedinam Tamakloe ebia wa file appeal na wa yesi wa start invoke processes no wa anya hwe aban sisa ye no 2025 I think February 2025 from the records of court we know say that time na the lawyers eko siki the leave of the court of appeal say omo pese omo file omo written submissions and a court of appeal ne ma omo kwan
and in fact I must say yeah now from 2024 now or yeah appeal no next appeal no in 2024
or filing notice of appeal in 2024
May 9th
2024 and since May 9th 2024 no sa yanko court anko kan wan se mu bia to say
there be and I say na maka no the ntia e wo misusu yem from a legal perspective of filing an application in 2024 no was to ensure say na be an application and statute bad because after 1 month no I this say bia and na court no man leave say oh considering the circumstances no ubetimi a file in February and the lawyers ekoji leave say omo person omo file omo written submission then omo koji leave ni say the period within which I was am file omo written submissions na etwem but say etwem process bi a was file o court etwem na court NDC wo court bia na say o ka say court ni o share court normal leave because of some circumstances normal reasons court need to me ma leave court ni grant omo leave and omo file omo written submissions from the records we know that Attorney General also responded to the written submissions appellant in the written submissions in Attorney General first response you who say or catch court and they say some document be record of proceedings ni be incomplete and that or more rely on the notes of the prosecution. Now subsequent look at proceedings now indeed court and rectify say na Attorney General ni raise and a court and order once usually ni say okoye appeal no I say or transmitted record of proceedings from high court to court of appeal say court of appeal ni the trial no into proceedings ni no I was say court
kukuru ni da come appeal court
say na be appeal court of appeal for no so be hwem one by one it's prosecution ni chair say omo record of proceedings no omo one e before the court no incomplete but court no rectify subsequently I think May 5th or so order the registry of the court no so omo no benya the omo no more proper custody say omo complete document ni ambra but from what we also know no omo the complete document ni ba no the Attorney General say aban you Attorney General no am file supplementary written submissions didn't America say and say once the first written submission of file here no ono aka wo say or file based on omo ankasa note a prosecutors no aye subsequently court and say okay document ni nia and rectify any nie it will second document ni exhibit ni nia ordinarily law mbrabia show but ordinarily if you want to make a compelling case you have to file a supplementary written submission say based on document na about to attention say from what we know no the Attorney General and yes sir fast forward and na court and the judgment aba say o evaluate proceedings ni nia trial court and conduct ye ni nia no prosecution ain't men prove your case beyond reasonable doubt and that judge na misdirected ho say o pushy evidential burden na wo prosecution so e di akwakogu accuse no so nti no say no there is a judge no wa err in law what they say the judge has erred in law nti consequently no almost set aside conviction and the sentence when your court will court. Now, remember the politics of the matter.
But what the answer is the politics of the matter no so. You have 500 million Ghana cedis now of the coin. 500,000 Ghana cedis now of the coin. Also pay 24% interest. And bank and say move to it's move from camera. You them say okwa efa so transmit e di sika to account ni mu no say me di sika no am through check so me say me dey brewa for evidential purposes intino me dey am through check na sa balance wo ma anya ne sa court abatampa for na anya ne sa and no di sika ne bre no but according to high appeal court no let it be sent PA mama no say mama no say
receipt
or receipt be or pay interest be say pay obatampa for no omo de mama sika nyina kwakoma no nti omo ne mama ne ka na fe eba ne say bio na yes my men send letter question mo fa me interest in mere me letter na buy ya say my men sign say ni interest no so say one wo ka wo ni sika nyina kokoma na e ba ne say na letter for san buy say me interest bi o say mo de ma me enti adu ade ba ko a appeal court ni gina so kan say so mo ni ma me ne ka mo de sika nyina kokoma na wia sa appeal sorry sa interest letter no efiri he enti na wo so tokuru bi da ho a wo ka so gina so de ebu na ten a nshada anya yi papa ba ko so mo san kan me bisa ni nyina sana ba betu nya kwan ayayi ene se omo yeso be training bi e de ama enkrofo bi
85,300 people
be training bi se sa training na be ye no ye no so be training na ye be ye yaw ye be ye kwasi ye be ye lawyer ye be obi training ti no anya hwe no e se wo ma ye training won anase ye se be training won no e ba be dia dance ye se o kan so we training yen na so wama o kan so be training yen nyina na so training pe tu pe sa dance yen no so no ama e wo court ho nti no so o kan so nipa so ku training na so anyi obi a media dance se wo training yo so wan training no eno ka so ono meyi no ho ano a enye ye eno so tosini ana kan tamato die wonyi se sa niema no sinto bi koso e wo the then attorney general na adwuma o ye mu eno nti de bia court betu be gina so de tu de sana mo na na
me I don't agree say sinto because attorney general adwuma because attorney general and I'm sure say in his best understanding of the case and the evidence available to him and or they put two in the docket together and or the court into no or no need to see no or prosecuting the case no nya conviction. I am very sure say if the attorney general did a sloppy job at the time anka court no endorsing a sloppy job no but nipa no appeal your as of right nipa na appeal trial court ni decision trial court of appeal no say trial court no say ni one consider into no nipa na was say ye jan man ko fie a court of appeal decision say na be kan court of appeal no obro high court no so the decision in as much as we may all disagree with it and I say in as much as I may say I think that the prosecution did a very thorough job. The Court of Appeal needing a decision about, and that remains a compelling judicial precedent and a compelling position of the law. In teenager, and I think say decision about
okay.
But send a American, or share the politics of it. A buy way a buyer or mobile, you know. As an mobile background, almost a mobile be a friend operation recover all the loot. In ya jitum so be ebe som Ghana na se wan fa kwan papa so na so de nsa bo Ghana sikemu a e wo so man nitimi gye ni sika because he sika de aye nioma pi so mo di ora ne baaye no ye nya yesusu emu ni so ora de e ya ade aba betwa afanu nyinia but abayi baaye ofa 2025 enko noli prosecutor enko a omo nkrofo a no mo court a abayi na koyi omo asem free court enko a ebe ya 10. The newly prosecuted cases attorney general na filing about 10 cases of NDC for no mujina court ebi ni koko board asemi Ras Steven Opunini Sedu Agongo omo asemi attorney general ne ba ye na we year free court say wa akwetia a discharge omo nkofie ofa Collins Dauda Segleme housing project here about $200 million and also no ojina court abayi ba ya we year assembly free court say Ora Collins Dauda enko Collins Dauda honorable NDC MP ebiem ofa Pandete Siama the current Bank of Ghana governor on also near the Nick Jina court for some $61 million banking sector na ho beba eba MP no and also attorney general ne say we yi assembly free ho onko the party ni ebiem ofa ambulance asemi ane no kra na wa appeal I think say the trial court no yi and also obaye no otwifi ho
court ne de yi be no ye
trial say omoko appeal omobaye no na attorney general no say of file processes been and also or withdraw asem no a free court and a number of cases attorney general na akwa withdraw enti you can say ni aboma media from a political perspective me who say Madam Sedinam Tamakloe sanka abindada no enti men wie prosecution no insecure the conviction anka trial ni busu koswa head ya koso ni nia it is clear san kono kra ni case na nko me file no le process kwa
yehwe bibi wo ha should we look at the political angle of it and as a legal angle of it na see ye di adwuma mra kwan a ye fa so di asem na see ye hwe be de kasa and as a political angle na see ye fa because see anya de sa ebema akwa say ayamanso but the reality na e bi so a until you share the legal aspect of the case.
There is the politics of it because you have an attorney general by and for original trial near we withdraw more 73 court and not the political opponent akwa jina court. If we say we are recovering the loot, allow the judicial process to go on. At the end of the day, no say court ne ka say nipa ne hu so Madam Sedinam Tamakloe court ne ka say ne hu so. He say ne hu so. Enti no uba abemu na say o de nkofo a standard trial a mu nia ka mu sika ni boma close to about $10 billion na waka so mu nia o mu nkofie wa withdraw mo charges ne say adanse eni hu nti no o mu nkofie no it raises political eyebrows and it raises the perception say what the prosecution no ade a what they victimize political opponent because by the way you nkofo nia akofie na akofo mo serve wa bandada mu no odi omo aba be gina court and omo de wo say o recover omo loot meanwhile nkofo ni bi so we standing court for the same loot
obi ba ka say 8 years wo bobo mpanyifo bi din kokobot Dr. Puni Sagremedie Collins Dauda TV ene wo mo a aika ka ni nyina no 8 years ifie nwotwe we dey find say first for year no crowd ya nya bibia mpo a second year but 7 years yet you nya conviction da you say asamuno o say justice delayed is justice denied see wonyina so ye nyina so mo dupa say nkofo na di bone na mpa did ne di embritin sa yet you nya conviction
ye di kan ye nyani nia na 7 years said nam Tamakloe asema ye ke
me kan de bi 7 years
e bi one no started 2019 into no nyani nia na within that time frame they toss me I agree with this justice delayed is justice denied however this is the freedom of an accused person na ye kan ho asemi I don't think say any court or any prosecutor should be in an ambulance mode or in an ambulance haste say ye pese ye wi obi asem ten near de no ko to afiase ipa na was so affording the right and a year also didi na asem and now me no ka say MPP appointees on Mujina court me come back legal team even in the legal vacation the court is expecting say ye beba court even in the legal vacation are you serious until what Chief Justice lawyer they call it the judge they so call holiday
okay
and usually it is in civil matters crano and but say no crano it is with the consent of the lawyers say bia omo beji atu mu so we bia ye wa say mo but in a high profile criminal case anybody can correct me this is the first time me who say and I met to say in a high profile case
okay
yama warrant to judge be say umbra number na say legal vacation there CI 47 they recognize it CI 19 Court of Appeal procedures recognize it yambra they recognize it criminal legal vacation there was say lawyers court no but here they say oral prosecutions they are going to be heard during the legal vacation then it raises the suspicion say idea course it is more or less of politics than law
because be samba osubio onamo one day and then na momo baye no no le prosecute man no le prosecute ma say na kwada akora na monu ade efe no le prosecute na yemfa toto ewra Sedinam Tamakloe die hu enhwe say what say judges in some in some be kura wo ho a meaning say sika ni be kura wo ho a anyo no tua ye omutua after ono eni ho am na say mampeni abandada we abreso eno mutua sika ni bi ba mutua sika ni na sa abreso nyina no ehho asotwe ono na woje mi ho sika no so yetua no wo abanya na onye na aban mo wotie nsem se de akoba ne nasefo ya wo mo abeso ye so bobo mo say my clear agent man or responsible sa ma say do ba bia edre mami choose ma be
kobna semadu mebo modern semetimi eyesu semadu wahu ade mabra ba me boy me ye nipa de fumu wo me ho nanso adia eye papa no mehwɛ sɛ an eye papa adia eye bɔne no mehwɛ sɛ eye bɔne. It should not matter where you stand politically. Inti no sɛ yɛde asɛm akɔto obi so ne yɛde no akɔnyina abɛn na aban kɔdu boni ya ɔno na bɔkɔ edu ɛmi yɛde nipa akɔgyina hɔ ɛhwɛhwɛ krataa mu ase adeɛ yɛkɔ anim a yɛbɛgu yɛn anim ase yɛbɛsɛn aban sika kwa ɛfiri sɛ yɛmema so no ɛmu nyɛ duru sɛ nipa no yɛbɛtumi anya no nti asɛm no pam no otwa no yɛntwa so pɔtɔ kasam yɛfrɛ ne nolly prosequa ne yɛtwa so a na me vondi a meti hei ya menya attorney general me prosecute na obebisa sɛ adan na asɛm a prosecutor ɔyɛ aban prosecutor attorney general de kɔto aban court no wɔhwehwɛ mu a sɛ wei no yɛkɔ yɛnim a ɛnyɛ yie ɛne nti yɛntwa so no na meyi ano a anhwɛ a na bɛntimi anye ano yie ɛtɔ so mie no ɛwɔ yɛ Ghana mmerapɔn mu no nolly prosequa is allowed ɛnyɛ bɔne ɛyade a mmerama ho kwan sɛ ɛtimi kɔ so nti ɛno no sɛ nkɛyɛ na ɛyɛ bɔne ɛtia yɛ mmera a nkɛmɛka ho asɛm nanso ɛntia yɛ mmera kwan biara so yɛmfa no nto nkyɛn yɛmmra Sedinam Tamakloe asɛm yi so wɔn sɛ me nua akasa no mebisa ne sɛ ebra na Sedinam Tamakloe ɛbɛtu kwan kwa aburokyire sɛ ne ho doodo no na court na nya ho kwan atoto nano ana na saa bere no na kwedu no kra nya mmɔ wieye ɛna maame no ɔfrɛ ɔmaa mu si wɔkɔhwɛ ne ho ɔkɔhwɛ ne ho ayarehwɛ ɛno no yɛ ade baako a sɛ yɛn nyinaa yɛgye tum na ɛda hɔ ɛni nti no kwedu a yɛde abɔ Sedinam Tamakloe nyinaa ɔbaatampa deɛ yɛ ɔkaayɛ sɛ ayi sika wɔ Maslok de kɔmaa wɔ mo na Maslok maame ka sɛ sɛdeɛ mo yɛ sika no nsi ho ambɛsɛ mo de se ho ne ayi no mempɛ mo nsɛm fa sika no mmra a friend is saying Maslok ɔno kyerɛ sɛ wɔsesa saa sika puduo ne nyinaa go Ghana must go mu montie me yo ahobrɛse ne ani die mu hwɛ wonim ɛtɔ de bi a etua wonyanko a wo fi sɛ etua bia nso nye bia na etua o onipa na etua no wo se sika puduo nyinaa sesa ne nyinaa de go Ghana must go mu ana so an dete na wa wobetam ye ana wode kotu maame ka mu total ana maame ne drive ya hu
maame ne kura nyi bia ma ne so fa faka
maame ne mpo afa bia ma no so anyi ntofo ana maame ne drive lawyer mo tie me yi o ana maame ne drive ya hu no odi sika no call ye obatampa ye bank meboa savings and loan papa ya waka na asem yi obi asabi one ko school kura we degree esua nyansa nim se de ya move sika enim se sika etisa no evidence say ba ho no it must be done through bank transfer or check for evidence sake wono no be ka kire yen say oh, hold on. Don't go there. I know what you want to do. Don't go there.
Na se papa ye ka say o interject. Na me me interject. No person o kire say. Sika etua by cash.
No. I've never said so. I've never said so. We're talking about the circumstances under which you are returning the money and the kind of money you are returning from one institution to the other, and you had the guts to tell us, say, my minister says, Ghana must go, mu. Not your personal money, your my personal money, institutional money to institutional money. Now, wono, what to me did to Musi says, go, Ghana must go, mu. And a swas, the candidate, ana maame ne jisika no drive call asem wo na choma na asem ye ka kire obi
na se maame ne se fam sika brɛ me sika no de brɛ me no yɛhwɛ in the first place
no come listen
ɔde sika ne kokoma bantampafo no me tie ɔrekɔma bantampafo no yɛmi sɛ ɔno so de Ghana must go mu na ɛkɔɔ yɛ ana so ɔde ma mu through check
oh god
na kɛse yɛtumi yɛhwɛ fi
ɛyɛ me tunyo bi sɛ me wo Jesus ultimate me wo Jesus ultimate
honorable for
me running no mesum no
Mimi to ma Sedinam Tamakloe honorable for o to mi ma Sedinam Tamakloe
baby I am free a fruit here no a honey free a sunny what you say pa me ni nam kwan be so no de sika ne ma mo wasisa sika no go Ghana must go mo ana so abre obatampa na the siden na the osisa go Ghana must go mo ana so abre maami wo gbacho na total filling station anya must lock office mpo the man must be prosecuted for that.
Now when the case we share no gbacho now
hold on that is his claim again. Sedinam Tamakloe was not interrogated to determine whether that statement was right or not. He was convicted in absentia. Menuyanum, siyakasa jailer. You would not wish that for even the worst of the worst enemies that you ever have. Mami wa ma, ewo kunu, ewo abusuya. Me kohwe me ho ayarehwe na maba. No obi anya ho kwan kokeka nsam ye egu ho nyina de agu court. Me yetimi de na akotum wabrawo ni ho. Me yefese ye bon nsam masangrofo yi. That financial practicer, an institution like Obatampa, na the manager timi yi sika gu bank back Ghana must go mu aso de koma another institution eye maslock no wetimi de akoma individual our total filling station claimed without any authentication, any evidence to prove that that man must be prosecuted. And no the ejan ho ana wo pese kasa na maame no wanya kwampo nyina no anka se an de to mesuru ye nokre ana enya nokre no ya try na absential na ya pronounce na guilty me de na kotum no watena ho saa na mfie du aba me ejan saa and the moral aspect of the matter yam fan to nchen mram kakra ya kana mrapon no article 137 clause 2 emma ho kwan se obi biara court di emuaya beba wo wasem ho a wonye ntum no wotumi kodan court a ewo soro esin court a edi asem no muaye edi aba no bese me kan twi se di obi abeti asem brase mu and the right to appeal is available to any individual as a Ghanaian, and the law guarantees that right without any ambiguity whatsoever at all. Emranama ho kwan se si edi asam bi diu na asam no wo fi se yamfa ni wo yie emrama ho kwan se wotumi kodan court a asosene court a edi asam no emu a ya ba wonyi ntum no nti Sedinam Tamakloe a lawyer for no yedi asam no aba ya moaya na anya wo mo dan pe and wo mo file a notice of appeal again manya nti say makinkan letter bi a former attorney general Jakpa ni Nyankwi Godfrey Dami ana wosrese Godfrey Dami a throw letter bi mehu say bra no ono ya attorney general no we who say omo file any notice of appeal we who unfortunately it is not the duty of the judgment debtors lawyers to serve the Attorney General of any notice of appeal. It is the duty of the court through the court bailiff to do that service. So man Wontumi meka nkyerɛ Sedinam Tamakloe ni lawyer for say woman file any notice of appeal. That must be established. Afi so we can kind judgment na abanwa from appeal court na we do up can from page 80 can come from page 80 na de ba bedru be 1995 thereabout na wo be hu ensem a appeal court no etutu egu fam na we bisa won say ei na yam hihie be ni wotam ma mi we akotum saa keke wabra mra bia mo de amoabo ne kwadu se wa ye ho bra mpo otie in our evidence act 1975C unim 1902C unim it is not the accused's responsibility to prove that he or she is guilty or not. It is the prosecution's responsibility to demonstrate why you think the accused person is guilty. Ade wo call law school first year pay your lecturer. Intime amenya lawyer ni mpo minimu a.
Yenti yefa ne say
say
ebia yesi eja kwabra wa wie nsu wi special nsu wi. Obi se mawia. Na se mawia no ono na so kire kwa hu se obekire wie se na mete ha na bi nso ye nwa na owura ha na be fa me phone na me de so camera no na bi si nsu to obanyina na mehwe no na ofa nsu no nwa na de fa no ode ko tia no ko no no kakra nsa na ode ko nti evidence ni video na metwa no eno ni
but it is now
so ko ba se won video no kasa me on of no fight na yese me make say nyame na me fire a
onim de enti agana mra no edi saa ade na be hye ho no kire se oni patrimo den oni patrimo sum
ntwaso nti
wo betimi atwa asem ago osu a wuyi wa no hwe anya yie ene se wodi asem to nipa na su a mo a wodi asem na ato ne so no kire akwan a wo fi se de wodi ato no so ya nokre na wonya ema nipa na wodi asem na ato no so no so ono na nkotwitwa nyi ne ho woti asem na meka na se enti Ghana mbra ne da hokrojen na so sa wo hwe Tamakloe de ya de abeyi a kamia ye se ye de asem ne nyina gu Tamakloe so no yenya na Tamakloe ankasa metwitwa nyi ne ho se anya nokre o kan se mmara mu san so a ahobrasie mu judge enye yesa o nyesa na Ghana mbra no ekere no aninti no appeal no ekere se asema ye de adi Sedinam Tamakloe no enye asam papa na matisa Attorney General Dominic Yini mi amebra pani wa kere se opeso okọ court batan kase anum eye Supreme Court ono nso emrama no ho kwan say wotimi ko Supreme Court akọ challenge the verdict of the appeal court. But listen, you see, you need to trace some things and see whether or not the journey you're embarking on, whether it's going to be fruitful or not. The appeal court judgment was unanimous. Judge Baku mienu miensa enyina akotena say this is a high profile case because it has some indirect political undertone. Because an indirect asem na abano anya politics, but you see the individual involved have some political affiliations. And intino uka ebia na enwere mu de politics ebenya political nsunsuanso obi and it is judge for betena asem we su a won be dom su ko yie said the Abaya will be uncle Casse, say, party be what Bemuntina judge in the person or Cassa say. And until they demonstrated and actually unveiled all their professionalism to give fidelity to the law in adjudicating and pronouncing judgment on these matters. What you say? Make can say? One in the war almost share who now almost share was cool no. Nina di go apono so. Adi ye dwuma hwehwe nneema wo kin tell me say obi ankofa judgment can come from page 80 eba no. Nsam wo mo kan ye a wo mo nyina adwene ko bankro. See ye nua Sedinam Tamakloe. The judgment wo mo de man wo high court no. Famra kwan so papa na ade no kotomo enye ye unanimously no. I wonder how Supreme Court would but it is the right of the Attorney General to go to court.
I don't think I can say kwesi kasa me kan bibi about that 500,000
no, I yes.
Say canon require no. Judge for na kan say. What's the discussion in a common Nipanevi? After Kraton or Trap can say Mufa interest in Emrano. I don't know, see, Quabna, enter them. Enter a son or mocha. A son say, yes, so I dance a farm, a castle or trainee, and as one trainee or castle training for 5,000, 2,000 training. A son say, I told you the car or the Sunday making a big room. Now can be a Supreme Court to make gymnastics. But that's say, wow, enter a Micasa, maybe I'm about. Supreme Court it does not take evidence on cases. The Supreme Court want to look at the legalities and the laws that were applied in determining the case at the lower court whether it is just. Who will evidence be adduced? A high court now be adducing those evidence. But if you do not have those evidence and you do not adduce those evidence at the high court, you don't expect the Supreme Court to give you the platform to adduce those evidence. Okay. These are law. These are two minutes. Question say mo here
we are so maybe 2 minutes now because on number 1 dey because the 5 minutes to nyom the 5 minutes to nyom
ma for this mama o say mo here mo claim Crawford do no so aka mo bi
me that's
into 1 minute prepare
metimi aka
mesa for rounds for full team
me din kan aka tell us ade a enye no na enye ade a enye na eye wodi asem to court na asem na ya to court no enye a ya to twene ma ni yeye se ayeye a ye de ko nani ma ni yeye ade a enye no enye
lawyer Dwana ya hwe wotie rule here by ye rule here by ye ya wodi me misa ane address da bi na fe misa question ankasa apiko gina say osie no wasi gina say Mami said Tamakloe decision ya court to take apiko take ni say Mami said Nataku why onye bone kura na why bone na so onye bone why bone na so onye bone person say me who answer me misa question
ada na obisa ya court aka no no kokko dey person for there
say me can say ye kodi asema prosecution no the right so or the president in the case in fact you can say it is a prosecution or the case ba it is so no prove defendant no dey what pa obebem one pensua obebem nti na man kwan say the prosecution can answer me nyina wi na so close to the case obetimi file it said menu e kan
submission of no case.
Submission of no case. But the court didn't decide, say, you have a case to answer. Because we are submission now, case to answer. And I'm just saying, now, case here yet. The lawyers were in court. Yes. Almost year cross-examination. Yes. Almost year cross-examination. Until the trial went on.
Yeah.
The fact said, no, it's neither here nor there. Great. There was a proper trial. So Yarena so niho na say court the field say the excuse that she is giving no and yet enough for the court to curtail their processes now. The court will continue. The issues now mean we come. Yes, on your lawyer need it, but also all kebi. That's fine. so who say obi a ya fan say onkonko ye adwuma wo public office emra eti no te wo anya private sector emra no say bindi ye nyina eti say wo na wo kokko say nkofo ye yesika koma we say fine interest in yenti mari draw mo fa yesika mre eti the process na sika ne ko no sa process na sika ne ba for record purposes say sika no aba it appears say there was no record of Sikano ever back. So Sikana and back, the nature say between Onu any Ekrofona or Moji Sikano. Ekrofona the Oma back court, prosecution the Oma back court, Oma testify. I was so no so bad, not that show the evidence.
Say be a scam in Saka.
Saka. Why am I a sad here? Into the court of a high court, what said then on me. If the matter meeting, are they a nationalistic? Me find the partisan because political joining the political party, they have a constitutional right, but it should not interfere in Adena and boy in Hobine.
I am Rano.
Emrano de Jina say the reason why I want Ghana is in Ghana. And just say because the way who first waiting in Ghana, Emrana establishing Ghana, it's in your constitution. Into constitution see this the public office adwuma emra wo why so faso enya emotional it is a emra no when timi animra no so na assemba yes so when timi animra no so na say a friend is saying kaba not just work also financial loss sika so move sika we the ko be a yetimi hu the other ko ya o me entitled to make say money laundering process of crime it no me dey say dem ti fe hu no court of appeal for decision no say one sided so me dey ewie it become once me bo ada I one sided in the but they say dem nua kan
no kwan be so na one sided
yes I say one side say yeah you say oh my me no ni what say dem nua kan say no ni what yeah di one say na also ma say dey fine home say dey di was
to the bro the
o be bad o man so eja so why am I because I right so baba be different
we also now Johnny
also the make us the nim so Johnny you the nim so Johnny but the lawyers were caught our year cross examination our president commission from your submissions cry and in your money 18 million at the end of the Ghana near Kenya politics so be a kodra aban adwuma so na say be a 91 million Ghana cedis ye hunu ba bi afa I was see bisa and your politics because okoko you know maslog whatever no and your NDC and your party no national and nyina yesika NDC for ne MPP for ne ayifo nya nyina yesika it is so you say kokko ya tuawka ye ma wala wanse ye ma onyoma na so untimi nkire ba bi yesika na fade ya eja say esi hwemu ye ntino say attorney general say oko supreme court dia Dominic minimum pa Dominic nye obi a sade ne nye no kro be ka say no kre ande minimum pa it is a Dominic an kasa ka say odo ko ani makwakwahwe decision no say dey tie na so be it also all right say dey o ka say ma me no right or do be ko also right or do be ko as the attorney general or attorney general of Ghana not attorney general of NDC it was feel say a bibi wo mo eso koya o ma ne nko no
ora la me hwe we wa say wo hwe decision ginasi a high court ni see ye em say evidence ni nyina abeto high court na nim ankurubo nyina baaye ndo gina so e di bu aten ana appeal court no so kire say enyina so a o gina so di bu aten no emu omre emu hojo emu ni namu nya den enti ebi ni mo ka say the then attorney general no anya na dwuma ye enu nti ena ma appeal court dey akokobam sakoye na dwuma ye na ka high court ni si gina wie ya even sa ka appeal court ni pa miensa no ka ba ko be ka say oh there be me nyintum the high court ye na eno ano no omo miensa ni nyina say high court gina sie no entwa wie enti na che say attorney general anya na dwuma ye wo no omo ya adwene sa
me yellow ebi atwa dey no the cases are court bebre our lawyers kita brief no mo yet ayada they so politics eja court say me who advice am dey man clients. Because our clients advice based upon the law, based upon the precedents. Maybe alone no wo. Ukokota decision be a judge in the ebe ho. Me na make a joke. Intermediate say maybe a difficult to have baby. I take it with a pinch of salt. High Court now in the case. Also on the final reason. So be convict. Why any day we? Who are right so also the Court of Appeal. So Court of Appeal for the normal yom decision say decision na High Court in the year. You need to you face on establishing the case. But let us go back and see what has happened. Is it not true? Say 500 come I said Jackpot case. Let's go for ambulance, bra. Ambulance now the buy no. And no man check car money ambulance. Ebidim. You see, no case to answer. There's a clear case to answer. Either obey no wako in the case. Okay, I don't know. Yes, I know catch them yet. Almost me father and man. Normally the human be shame later. What did I make an answer? And you know, state issues, national issues, the account was. The Debbie Maker said, "Oh, water down the law no, because of politics." That you will also know about Benjamin. I say, "Oh, if you see a something, you just the tribunal's neighbor." Obe won 2028. What lose? Nothing. Tribunals no. Every tribunals no. So Bekaya, so cause financial loss to the state. NDC for the buy. NDC for government. Government in power at that time. Satana, a friend saying, Gerolins, and the buy. Woman, 2000 NPP for be winning here. Now, our cause financial loss will fall. And I'm going GNPC. It is who's a Kebiaba home. A can you hear a guarantee? Chachuchikata, a year. And a guarantee, the colo guarantee, no timer, na by a fiso. And then there's a Sahula balloon. And to be a woo ye be. And so when years or China, because I am Mra. Now you know better how forever and if you're Musuyi. And you know, me mom dear. Me abide me wo state afa. Me knew ha and I mean ha me wo state afa. So because yet state public or your public juma. That's a sign you my way by I say femu yi. Afeni e ka ba no le posekwa. No le posekwa say just say bia another attorney general baba ka say case no pese me ye. And no just say a finality. I just on one attorney general because okay na me can come ahwe ni here me feel say me sign edeba forward. It is a finality. It is not the end of the matter. Obi from a bachelor. Because no me pese me proceed. But the point na me make it say adentina one ma court na any asem. So officer case ni nya. Say it is the benefit of the person who's been accused. It had no one court in any 7 years. One guy said no, don't get him. State funds.
No, we should make 8 years, 7 years, 6 years.
And then resources they wait. I
know so.
Obi Oho any land case, if you have 15 years, that case they cost only the air cost. My track court to them, judge no. We share that I'm got to chiro na make say maybe lawyers from here make cases man. To me chiro na make. Judge ni 20 cases. I know I journey 2 weeks. Oya no wa journey 3 weeks. Oya no wa journey. Wa ma say kwada kwa almost October, November. No just a year now end no. It the judge is so packed to say. Oh, TV we case in tem. And then last make a check for since that a tribunals neighbor. Yes, certificates can set up more courts. Near training more 300 judges spend the whole program. 300 the whole country. And no mudi some cases we be now. It is the delay in our courts, you know. And ya bua payo. And yet the Lord about judges, you know, so I want to me. Imagine say judge in 20 cases. Or your way, you no assign irrecability na adwene. No assign about the name first. And anybody that's anybody no bit me answer. Why you expect any good stuff to come from the country, masa? I didn't there. Me dey Gina Ghana in Namu. Obi biara wo ba fa ga fence wo ba be adwuma ma ban na Wontumi mbu akonta ni ye no e wo se ani udi na me feel say there must be laws, proper laws that hold public officers. For example, you see a license to build. Now public officer waka sign a year man say on go sit down waterway. Ne yesi nipa ne dan ne yemu na nipa na ma order nan.
Ono don nam baby.
Ono nam baby. Eti there must be a law. Government akwa no slow say obey say dem because ya obey prison. Say nyoma bebre koso. But me dey me gina ha. Me go gina ha na me go gina because I'm benefit me.
Yes, the political twist of it, you know. Amana Baba say no the legal aspect of the issue na kasa na dey aton check and a political angle no na ya fa ne sa. What did he say? And no betumi abo because aba ne san so a ma atemuafo no ye judicial system no ye ma no kofom effect ben na enya e international community no say o man yi kura no o judicial system no shedan ko ye investor bi ba kura na dem hwehwe no.
Tio. Hwe sa OSP issue about Oforiate. Who the Americans in the country? I don't see any case be a red alert, you know. You can, my partner's tradition, maybe a farmer because any case be a. But it just be a case. But the way they ordered it on a political basis, no, it created the users that wait to make a seek political asylum. See, chase one, sir. Because the country almost chased him into. Okay, if you without a friend saying warrant. Now only ho na why say the lawyer say present me bi wo ayi e ma hwe e na ya omo law no e clean o into 1 2 3 9 years my decision na we enti no me pa mo omo chopi omo tete san konwa mu no omo tete wonu enkrofo bi hwe yen wa breach because omo ba enti omo nyoma the way I say you accept them ran e kan no
Okay.
Na nipa no finding the guilty. Yes, obi ebe who so going why are there and you are finding the guilty. Na you twist it, yeah, in the case we and just we the ebe. I know the massa.
Ebe hagin. Lawyer me dance. Yeah. Yeah, me there be bia na me kan say me say say running state institutions ni nyina down wa. Ebere bi be so no. Ebe kwa san be sia ya yeso. Me adwene ho ahwade bi din say ade no yesi ye de mra na ye adwuma nti mra no sisi de mra na ka no eno na aka say ye obi not protocol say hwan you know eno emphasize me ho hwe but akoko take some political twist bi a ama the legal aspect of it na ka betuma gina so kwade asua bibi de a kire nkwala bi law students ade da chi bi kura no it says a law student we which any side what is our case ruling ikra no e na dey a political agenda obinya e dey fa ho onya the legal agenda so nya no dey adwuma no ruling ni high court there appeal court there three ni nyina say nyina so bi nche da enim and the process is a firm where you do be adro ni yawo memo 15 minutes
jameda sepa enra na me say ya na beba I had a very long week. But metana say almost at 2 a.m. na medasotio. I read the entire 94 pages because I knew some politicians by the and I wanted na me susu say masudi say me some watie for anopai medal producer na say. I tried to summarize the 94 pages into the essential part into me send them our producer no but Eja, me that's so me 15 minutes. I will go into the matters. I will just state there. I don't have the record of the appeal. Into me need all the record. Into everything I'm saying is based on the judgment of the judges because I know na makai. Eja, you've asked very, very important questions and I so be politicians will be action there a boa or no be there can right. In my view, the more important question started with the nature of the appeal. Until filing appeal, there was what we call preliminary legal objection. Say, asem no kwa no na uni ha. Inti uni hu kwai kwa say uba appeal. And that's where I want to start from. And I thought that was very interesting because that's a pure technical legal argument. To say, you don't even subject yourself to the process until you buy appeal because until by dint of having you shouldn't even be coming.
No.
And I think that it would have been good to go into the merit, but unfortunately, no. The decision of whether or not say YMB appeal Numukrano was a question of answer now be raising legal objection or court of appeal. No, there are basic things. There's a form, there's a structure. You need to put them on notice. In Tiakamia, I said, even the process, I was say a dear anymore to raise the legal objection. No, states now and yet into that legal objection. Now, I say you're setting aside. But I think that would have been very interesting, to know, because she was extradited, because no one didn't pay by. Say no one out there pay by. Who can say appeal because you didn't even subject yourself to the process. And so that was set aside. I thought that would have been interesting to put the whole matter to rest, but we didn't get the benefit because prosecution in sense of
prosecution. The prosecution leading to her conviction.
No. In terms of the legal objection, no. Mrakwanya also faso a raising legal objection, no. One fasa Mrakwanya to raise the legal objection. So legal objection, yes, set aside, and I call the merit of the case. Now I'll bear the merit of the case. Eja, okay, and as I said, Mina Medase. The fonts are a bit too small. I should have done a better work at projecting it better. The Nyamansia and Yera no Kabi Ugupi charges 78 in Nyamansia. Even the numbering was wrong. Even the numbering of the charges, but numbering was wrong, and it was raised by the Court of Appeal. Eja, me bo ko do 78 Sebi enye fishing expedition na mede bibia sha no na mekoto se anye bia ba ko begina de mede baba obi ano e wo se e wo fapem na gina bibi so na the constitution 1902 say I should present to you in sufficient detail, and that is relevant because Court of Appeal gina so the ball ko adu ni bi tugu ye say mabo ko bi say jawa ye we I was me catch you say eda say uye we ofa we na wo djuma udi ye nti wo kwa adumie nti the edikan on the sex issues the edikan is still in a conspiracy to steal. There is willful causing financial loss and conspiracy to willfully cause financial. There's causing loss to public property, there's money laundering, there's improper payment of public funds, and there's unauthorized commitment and procurement act. Nti Ugupi 78 ni na insia ni. Eja de intina high court jina so the bua no for on the stealing matter no. Stealing no the edika documentation say nya no on the Obatampa 500,000 ekoye. Ye wakrata bi a wasign say a receipt. Because o a letter from Maslock eko Obatampa eko ka say usika no unsanya nka nti omofa interest mbrew eno omo say omo no ngita hodie through WhatsApp omo kai wo say sika no say the bro obacho na nti the bro obacho na dey no wasa trade letter every Maslock abrem me say message do ka na some
WhatsApp message no so
that's because the Supreme Court specifically said it says WhatsApp messages mbakokra and backward, and this is important. Now you see, and I make I say it's a question of whether or not, and what I'm doing is only presenting the decision as I've read it and as I understand it. And to say, okay, say because say akoya fa nun komo, bako say me discan bro bachona, bako say but one first gan because don't forget, Yoko friend no, mamina deny, right? So right from the beginning, nya fe no kase at no point no admit say waje 500,000 inti kwadu bofo from Obatampa say ye di sika na brewo Ghana must go mu ma me say me nsanka ye but ye wo krata ma me nsa sha no after who claim say o de abre no e be busa say sika no fama de abre me as Maslow o si why receipt be or no ankasa sign receipt be say or the sikana bro. Na court and say even that as evidence, I was saying I will certify because it's a public institution, so there is a requirement for evidence. It's a receipt no kwano. It doesn't meet the basic criteria for an evidence. But the bigger question they say ususu say because now the question is a doubt. Other no one can say letter free Maslow. Abe or say misika breme. So himself wa general bachono total. So ordinarily it raises doubt. And then you said the doubt accrues to the benefit of the accused. It is a and yanti and one say bia bama and man say the yabo no kwa do no odibem kosi say bebu no for. And you see that constitutional provision is very, very interesting, and I'm sure say he is a defense attorney now inti enyadia obe siki to say obe yi bibia free say obi dibem because their own penny say on my money you know before mine to me are persecuting our townful, right? What you don't want is an attorney general to become a persecutor general, and even you take the political undertones are baby say the all party and they say oh the case mean no they are now and they say one ye and it's my humble view that particularly when I saw the letter from the respected Godfred Odame, I thought that the case could have been. This is not a case in my deepest humility to him. You lose because I actually think that there was wrongdoing. This is my personal opinion, but I think the prosecution did a very, very horrible job. My humble view, right? Eja, aden na ususu say. The nature of the Sikano, because now there is doubt. Watre letter through Maslow, Sikano. There is a new receipt coming. Akoye obatan pafono ano asem, ene maamena no asem. Lawyer kase she's not even bound to say obeka bibia. Into the fact only no does not mean anything. Only ho. But one also prove say indeed Sikano corner chain. Only bibia is because he said the person who is retorted, but senior yera vondi busaya no. Sebi obatampa enye kitchen edwa. Dealing in Bachona total for 500,000 belonging to a Maslow that was sent through an account. Does it raise reasonable doubt? My answer is yes. The second issue on the stealing and fraud, no, that training 85,300 people. Yes, so mobile sensitization now, you have 20 CDs. Into 20 CDs, not the multiply 85,300 now, 1.7 million and 6 B that's all. But no account no 1.8 million. Like to say approval 1.7, but broso 1.8 million. Question and they say Yoko Yebusanu in cross examination. Into 80 mostly there's an auditor auditing firm and the year way. Nipa 85,000 mubusa nipa baako anambienu
so omu jan training na
se omu ye ya na Yoko se omanye eja
be se nipa na ya se ya train omu no ye nya baako kura ya da
85,000 ye ntima musa baako anambienu se yesi e be ma obi 20 CDs ebaso and the evidence is that omu Yoko se original regional directors nyensa adansi die say training na maso regional directors adan yan fa mo mama court because lawyer Becca Church say here say o ko for nipa miensa o mo te ase abegina say oh we ka kire me say training na maso nipa no we fa ne bra court then they see prosecution ho kwan say o mo decide nipa miensa na be court ama o mo abedi o madanse then they see Yoko ho kwan say ko mbebusa say nipa 85,000 now also here sensitization no baako we mame number na me for musa say baso ana maso eja so does that also raise doubt? I think it does. Where does the doubt accrue to? It accrues to the benefit of the accused. Eja the toso miensa which is PW1 which is here Sedinam
sticker
who was the MD, Obey MD of Maslock, and PW5. On the record, there are clear things. Yes, document. Mo ye audited che. Mo who said document. Near money be a including the Makola the burning you did. There's a report that suggests say Muamu who said Sikano was actually paid, and it was admitted in cross-examination. Into the question is, I then the man from Muamu internal report amaya ambetuga na prosecution eyi bi fimu and I say eyi de M1 fimu. The question of ex gratia, I say yetie sika bi amano no. Yetie sika no the yebusa PW5. When they approve sika no, PW5 say me na me approve here. Satan na when the wa buy mu na ma me no wa buy mu. Ni ese nya buy mu. This is the first time I am following the facts of the case as a lawyer, not as listening to the public commentary. And Mimi Susuyemu, I think that the prosecution, yeah, was assembly musa prosecution. Because Makacho said, me, my humble view is there was real questions to answer. But the entire law, Nashishan said the burden of proof no was wrong. Say, lawyer, the other catch is a criminal court. I hardly do me in all my practice. Criminal court my bakope and no crown man ye me the mobi because the way say would you be quite fierce no eja it's too much. Say why nye adwumani ya enye se bio enye sikasem ana enye ajapade bi keke nipa kro be quite fierce. So me as a matter of principle I don't do criminal cases because the stakes are too high. I'm not afraid of the stakes. But I think that it needs the level of diligence and commitment. I was say from both prosecution, need the defense side. No, Sebi unya huwa kabre entrance se na metrance 2 a America case amenya kokoya medeta no pa yenye. The prosecution owes all of us a big apology in my view because eja case no idea there's clear signal and the court of appeal and kasema many are innocent. They are only saying said the burden of proof, what is required to make her say a bemon required do no. Abaya and mitisa standard no, and there are two different things. Yes, she's been acquitted and discharged based on the fact say Susudia was saying ka yendru no, and the mon required do yendru sa Susudia no. And Teresa said you are on your bonnet, and I'm sure on one can say on him say there are some things that she needs to answer for. That's the first. On the second part of willful causing financial loss, no. Court of Appeal, Nina so ne say charge no say na meka 19(2) of the Constitution say I was say you give them the detail what they are why. Court ne say charges ni bebre wo ho a ye kan a ye hu dia maame na ye nti maame na nkasa bone ba na ye no e wo say what charge sheet ne so but charge sheet no does not reflect the nature of that and there is a case say charge sheet ni a defective not charge sheet na defective no so a prosecutor enye ye nti sa no na wo say ye twa charge ni nyina mu because sabi ye all charge no in order to in sufficient detail say this is this is your act a mass in the buyer no eja this is basic criminal law matters. Yes, there is sufficient law to say substance over form inti the fact say criminal case in fact technicalities and charge ningu biasa but the decision of the court I think it's Mercer Thompson if I'm not mistaken the case may say the 19(2) near constitutional pedestal into constitution say about I say a child in sufficient detail their wire into yen to me in fact court act new constitution no ejina appear was he say about do I was a charge no chira their wire no to me free because another law which is the court act say say your boy kwa any kwa say technicalities e na technicalities so the to charge sheet na but that case is very clear to say kwa do no constitution say your boy kwa do I will say nempem edru ni say I will say you can dia why insufficient detail chill but kwa do na ya bono no sa details
me tell ni nyina na che say kwa do no ya nhyeda nya hwehwemu ankwa chiri yie ama yenye nyina so emu odu amfa emua amfa ni asam ne dia ene na high court gina si no si ye no otimafo na buate anchi ana.
That's a very 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 good question and I know say the Obi Obeka Court of Appeal decision ni bia I'm sure including the respected Afiasewa who was a judge in the matter would realize that the Court of Appeal is directly impugning the judgment because what they are saying they say one kasa and yera kwesi kaye say Court of Appeal say try court misdirected on one kasa no because you say court do no de owo asudie so ochire enye de yabo no court do no
yamo de obo court
do na wa asudie so be chire mu a chinje bia ni ho say asem no say netie. But I come here say because the child was put in the negative, no. Otemofo no susu say, oh, because oma asudi no say na sitia no is been framed in the way say udi for umo metremu de nti a wuni for. And because one metremu de nti a ondi for nti the Court of Appeal nipa miensa no the three wise men no esusu say the trial court erred in deciding again. If you look at the nature of the reasoning of the 94 pages, it's very difficult not to agree with them, right? It's very difficult not to agree with them. But ja maminka we easy.
Sima na ya.
Eja medema no si no. Me susu yem no. You see, anytime I the politics and makawo fear, anytime our politics ni bedi enim no, we create some of these problems. Say ya dear say prosecutors no ya one drain so ya born no kwadwa sabi they didn't even need all the 76 charges, right? You needed one or two and you needed sufficiency and you needed detail so obey wa juma ye because sabi all the 78 no baku bia to me and I think that was a mind ya fani nyina ngunu so and baku failure anya bia 78 there na baku bi beso online but I think say prosecutors awa asudie say be the integrity of the prosecutorial powers no mu ye do omai bo bi kwa bi say be anya asem ketwa and ye wo ha nyina no ye pese wo wa ye omai boni ekwa afiase but the last thing ye pen say ye be weaken the integrity of our criminal process because eno no omai to me no etimi gina wach etimi eka wo she inti na law student bia beka cho say the thinking of criminal justice ne say yama abonefo oha ana odu enko kosi say ye di nipa tenteni or nipa oteni ni ba ko beka afiase no nipa oha a wa ye bone enko so that's the reasoning of the jurisprudence of criminal proceedings on that basis yente politics ne so okay. In this case, if the professional pursuit was done, clear investigations were done in the way Minsusu Sebi Kamameno would get the liberty she's getting and the loophole she's getting. Okay. But the fact is, if you read the judgment of the Court of Appeal, it's very, very difficult to think they are wrong.
Okay. Topic na kan kwa ye be chef region
a few minutes
me bia 3 minutes na ye de ye nti kwasi na wo se me ma wa ye hwe ya o kan sen bi se nipa ba se wo bia wo di adanse nipa se be di adanse nipa be ye implement de watching 85,000 and they say koko training omo ba ko kure tuwa me gina court say
85,300
kure tuwa me gina court say me eja kwa break say be training me ayi say de sika ye kokrodoma nso ye training me ba ko kure tumi anko ani attorney general no ne investigators na anya omadwuma yi 2 sika na wo so de akokombo nipa no onipa no se sika no wo so de abrɛ me nisha me se dabi wo so se me de brɛ wo de brɛ me WhatsApp message a e kire say madam Sedinam Tamakloe ebia say the money has been sent to you. Oh okay, I need I have received it blah blah. For WhatsApp message den so bra eno so ntumi afa ama anya attorney general na anya na adwuma yenti na no so see ye ma ni mi eno do de efa de mi eno no crack.
I would have even doubt the WhatsApp message if they have even sent any WhatsApp message.
Yeah, enti ma me mo 3 minutes.
Jacob, now may I answer a question in here, but
3 minutes will me patch.
But I have some 4 points I'm a person me and clear.
3 minutes.
The kind from conversation now question in here, my back conclusion says it's a Ghana had there were 2 forms of justice.
And that is
one for the ruling members of the ruling party and one for members of the opposition party. And I'll establish why. Honorable Kasano, Honorable made a fundamental point. A stress is a seminar about Tampa manager Nebeka and a new massem. Now, even Kranobeti media dance Krumu Etia, Madam Sedinam.
So, Wontumi there.
Madam Sedinam. Oh no, that's what you said.
No, that's why
it's my 3 minutes. I want 3 minutes. Enti honorable yes na papa ne kase manager ne kase na say prosecution witness ne kase or discuss ko see car nim ne sa nyoma ni nia eye na num asem yentimi ngina sa na num asem ne so fa convict you bi me pa cho o kan court of appeal judgment we now tie the honorable ka now they compare judgment convicted Chairman Wontumi.
But some go appeal.
Chairman Wontumi pacho. Chairman Wontumi. Then tia ye dey no court to afiase ne say.
You guys are not helping.
Prosecution witnesses no and the bedi adance ye say or the assassin no for a certain purpose. Judge no jitu mu say there is no direct evidence into gina asem prosecution witnesses ne be kan ye so. And o twa asem ne hu bi de ye adance ye ehwe nsem ni nia senia circumstances ni event ni nia no de ba the conclusion say Chairman Wontumi edifo. Now if ye kasa asem we say obi enu masem entimi mfo obi nkwa afiase me pa cho Chairman Wontumi obi enu masem e de na akwa kopie baby o we
and it two different it's scenario two different
cases criminal matters
mama ne time ni mama bako ye say be the second abro or Ghana must go mu I don't know pacho and ni evidence bi abia me wa chiri no o ka say ogina bachona tota nti enfance bachona tota no ogina na ho nye say bia atechemu na na adro ho
but there's also a letter from Maslow
you could know how bia yehu but Chairman Wontumi de no asase nti ne say kwa asase no so be hu say bibia akoso ho nti no ya dance ya betu de
good Jacob na wo analogy ni excellent when so ye sika no ko Maslow account man ke be wo Maslow bank account mu. It's the same thing. In here, the same standard, the same burden of proof, the same evidential burden. Now, in the prevailing case, you know, honorable von this and can say, say, nipa ne kaso discount command na video bi ani ho, infoni bi ani ho, intinient mi ngina nipa ne numa sem, nso emfa nka se the okan ye no kra. Me pa prosecution witnesses no mo ka se Chairman Wontumi the assassin mo so mo ko illegal mine na video. Now audio honorable me try wa ha okay no honorable okay say video be here
me famra eja kwa na wi aye
me pato Chairman Wontumi no ye bo video bi kire yen say
me na me ma ka bibi sa
am so me the madwin ka
me illustration
am so me ye Chairman Wontumi asem no prosecution witness me ka video nie anase audio nie eye no kra say Chairman Wontumi the assassin no my say yem koni yem fan kwa galamse ni yem fanteneka omo fa bibi asamba eyo manu masem e no mo de baaye ebiem ye ni aye bisa question around this table say identity na beneficiaries of training no yem for one page na court prosecution ni case ni say training ne kra amba so there were no beneficiaries in the case of Chairman Wontumi identity na prosecution witness ne ka say and now prosecutors ne allege say Chairman Wontumi de nkofo no prosecution witness ne ko bi hokoto excavator na say excavator ne for purposes of illegal and na yankofa nipa na omoto excavator no won ho amma testify say they came to purchase the excavator for purposes of illegal mining and that is what they told me and that who adanse nie I don't know young for number. So you see, this is the same criminal matter. It's the same burden, but when you compare the two, you realize that there is a major defect somewhere. Again, in terms of Wontumi asem no.
The question is, no. Of course, 6 minutes. There were 3. But last 1 minute.
But once the first round, no man 10 minutes. But what my lawyer from 15. Time na your time. It's your discretion. But Wadaroma.
Say. Maybe 2 way. Me get bias.
Minim say Wadaroma.
Wa asamu no.
Oh yeah, justice Bafuboni. Justice Bafuboni. Me secure leave.
Me ma time.
Me secure leave. But you me time. We dey family home be srel.
So kasa mo time.
Leave na me secure. Leave na me secure.
More than 10 minutes.
You leave na me secure. Justice Bafuboni me srel. And the point I'm making is over the 2 cases now.
Okay.
Now compare the basis upon which Chairman Wontumi has been convicted. Now for the basis upon which Madam Sedinam Tamakloe has been released there. Wontumi say it raises much to be desired. Say, is this the same standard of proof? Is this the same evidential burden? Mbrakona near the year Jumanana.
Okay.
Honorable one this and Kasim be say, Asute Media and Sedinam Tamakloe to say, Obeba be kase ebia sika no mo de maami ana e wo so mo no mo problem me pa cho Chairman Wontumi asem no ye dia so de no to Chairman Wontumi so say wo so establish say one fast asem na mo for illegal mining and that you see Chairman Wontumi intima establish say intini ye de na kwa afiase we cry circumstantial evidence pointing to 2 reasonable conclusions no ye de obi akwa kogina afiase inti asem me de me what can say judgments are for posterity.
Okay.
Judgments are not for a particular individual, and that we share the course now. It raises politics. Me manusi finally. Unim say judgment na bana. See my Google or graphic online or online PA. It is not even the true certified copy from the court, which means the judgment was not released by the registry of the court. So counsel, it begs for the question. Say no. Who released this judgment? No, it's a valid concern I'm making, and that is the same. And I have proof here
from
and I'm saying, online platforms. The judgment has been published all over. Anybody can Google. Anybody can Google.
After ruling, no. Report. Yeah, reporters cracker said that day. Now, almost just after judgment, publish it.
And I'm saying, sir. Online.
Yes, certified true copy.
Anybody can check.
Okay, me that's it.
Online. And I'm saying, sir.
Yeah, judges no be here.
No one since
no one since I need your registry. No registry. Need your 2 judicial service. No registry. Need your 2 judicial service. Let watermark letter.
Social media.
Me pacho.
Every baby, but mention every baby a question the way. We see when they be online. When will baby or paper? Any, and a judge for no, or man release at the end.
What a judge for a judge for
a friend is saying,
and a judge and a release judge.
One release it was one
registry of the
registry. The one the catcher of say registry be about by arguments or the baby to paper. Now where who Sadia knew what paper one? Walk about registry and I say Ibia Subo.
No, we judge
Obianka Hinchira was
there no judgment.
Can I was very quiet.
You are not quiet. You are not quiet. You are not quiet. So please. There be a move for my bem 1. 3 remaining.
The mention say. You hear him say judgment about registry no never release judgment no. Asema maybe say wo si we hunu biribi e wo pepem. Who baby our social media until say registry na abaka say ye the 2 people ye the 2 social media no you have no right to question them. No. Why did they release what was not signed? In any case they didn't tell you they've released it into social media.
You're not
they didn't.
You're not
so I mean what are you asking them anyway? That's a no nancha. Chairman Wontumi MPP. And again, with the greatest respect to His Excellency Nana Danko Akufo-Addo, Mamua Brantiano. Yes, you see, any time into me can be brave. A brana Abujinapa or ye one Kasawa appointee, Land and Natural Resource Minister. A debate just say,
akonta mining any Wontumi illegal mining no dia Nana do Dankwa Akufo-Addo ye ne say okogina sempie so ka say akonta mining and Wontumi are not involved in illegal money. You see, if you do not reprimand your child at home,
can you produce the letter?
Hold on. If you do not reprimand your child at home, the law shall reprimand your child for you publicly, and that's what is happening to. And that is, and that is what is happening to Wontumi. The MPP
it's politics, it's not
refused.
If I show cheap program here.
Okay, that's it.
This is why English teacher. MPP
Entimi antwe woni abofra Wontumi aso wo fie awo dem. Ghana mara betwe waso a wo betwe waso wo badwam. Eno na ma Wontumi akodi awo komi mu. Nti so babo obi subo a na do Dankwa Akufo-Addo ni MPP ana ama Wontumi ebrebre awo
politics na
abranti afi no 50 years eni ko 2 years
train aso
ekodi 20 years yes no
the men binim judicial power ye be je okro
afi mo tie
Who we 55? 58. So who we 55?
Inti Bible kura ka say obi a wodi obi bekọ kote emfa no kwa efiase no na saa nipa no woye obi a woye uni owudi ni ya ase.
No, we need scripture.
It's a very horrible place you will want anybody to go.
Versberg. Honorable, you are quoting the Bible. Honorable, you are quoting
Bible. They say Sedinam Tamakloe na samano. So we shall summon Fitiasia because ye ya ahobrasini ani die mu no so a appeal court judge for the able to just say no media misom ebere bi ba na wo ya attorney general na wo gina o man na mu akodi asam a ya empepere wo ho ni asam no abra wo ni nyina so the asam ni ye na you see Godfred Dame attorney generalship is becoming one too many of irregularities in some cases that are very high profile. So we compare Jakpa Sansam calling him any a day at the before for a year. You know, you do not adduce any proper evidence in court. I mean, you don't need 78 you know. I mean, just one or two, you will do your cases. And I really feel that. Sedinam Tamakloe.
Say Animal Kingdom, a home crumple Mraya Juma. Will be a more good Mraya Juma. Ubu and Gumra so I'm Racho Wasu. Na yensho kwa ya tutu ya niyama so mine. Bibi bana ya kan wasamo a se bia woka na ankoye ama party A a wo ye party B ni. Woka kana anko party B ni ankoye ama wo ye party A ni. There's no objectivity over the ayemu us or mine. Ya didi mo ama se judiciary no kura no. Abo awura ho.
Anya is do.
It is yanhwe ya wonyi ni se. Yadi eti kura baby a ebetu do hawa breye pa because e say na kan say obi a say asem bi bana say the politics ko taron kakra bi pepepe na say ade no say emra be adwuma no na politics na di adwuma e boye ni
eja me mom die me feel
MP
judiciary no e say
na me boa
tio nyabo treo
me boa
pam ebrem mesem
judiciary no e say ye independent. It needs a president in the chief justice. Because the presumption is or the nipa na akwakotina ho. He can reach that person.
Yeah, be so na
yes, but Tio, you can say a conflict of interest. etrimo etrimo nya se bia they happen there a manifestation of etrimo ade no enti ne se me na ma de wakwakotra ho na me pse case we masa akwe case mamia o face obeka se there bi that is the point enti no se de be ya ye betimi ama judges no omo independent no who so be anti me pamo me fie kodwa we so ana me punishment no e from ye wholly independent near per system bia ye di chief justice either say by the senior most and eba intenye so be na eba be you time do a if it's the time na so una wo ba
the constitutional review committee for say 10 years no wo ji tum say yeah
well 10 years say
guaranteed
as a chief justice 10 years no
there be them before say again because if the chief justice is not good and 10 years not that's what
yes, so what I say
and the make the independence of the judiciary has got nothing to do with 10 years the independence of the judiciary say akonwa ya otisui obi antimi mba befa ekwan foforo bi so influence and entertain because the yi chief justice back na yi o chief justice back ti akonwa so there's no prima facie case you know at the end instance here but he himself president otisui from the time no your campaign also be chief justice there was no evidence
on any general secretary
also be electoral commission there was no evidence at that time
you know better
better this is not politics these are national issues so a lawyer ni na ka court na ka sama make and ka be hu say akaka kre bi ni edu nkrama no so
the theater
because there's no justice anymore
no that is not it
I am totally aligned
lawyers ni a day no me were bear 15 cases ekoso a day our lawyers work quarter omo ye be cases amami what is the mechanism the woman na e ban
ruling na ban
o shake ruling no ne emrano even the president because a practicing lawyer will be a oni be a law no work at any given time intellectual lawyer there oto no keka kanesem but practicing lawyer oni be a law no work it is all be to papa ifo about ordinary case abana be to do for e so to do for be a law no work o ye no wie no aka kira kwa so o case e good pa o be win o kokota ruling back e be ba no ajo kodu supreme court asa na yetimi overturn it no ama a trials ni eyi na am for you na too expensive it will be one cop first one na somewhere do we lose o this can be on the better one nti
no better if
you find the property
it's true I agree
with
vacation I was saying judiciary need and in Nigerian temo say legislature ye case ye law bi na senya judiciary na beka say some constitution change to the president ni ye bibia judiciary na compromise ye wu
even in coup d'etats they exist
ye wu and on be said the center will not hold into ebe one soldier for no mo ka say we ya ama for be support into engwe enti masa enye joke when ye politics now wo ye I'm very concerned about how they are making because me dey me who
can say even legal vacation
because
so the two of you because you seems to agree with everything
because you
because you are practicing lawyers you are not
I'm not but I'm not religious in the law
Liberia say about 300 years cities say Sierra Leone, Rwanda, and when they see say the systems that hold the country together compromised that is when
put the law into their hands.
Wontumi, mamika Wontumi kakre. Me the question na me be some a lawyer for any politicians. Amotia. Sasa sina yesi two galam say was no. Na license was so see two good was one.
Aye. Na Wontumi was license.
Enti me be question.
The license is absolute. So what be some year no.
License better than absolute.
Would mami be some question.
I'm part of
me say na license was one.
Resource committee. So I know what I'm talking about.
Akwana me say question fufuo. Akwana oba asase no so. Oba be reclamation here so too man. Obi man the document because Chrome has say lawyers. So me person me mount a year assignment of my year now. By word of mouth and
by document.
And then I woke up. Oh, kase the evidence in my show. It is a nipa no when to me evidence document we no dey man me wan go seek consent. I dey think na judge never wait there no. The one first the evidence dey no. I know there. I very evidential.
You see the theater of the absurd.
No, it doesn't mean you should box me. It doesn't mean you should box me. The reality, whether large scale or whatever, medium, one kind of medium scale, small scale. No, Ojia, no, I done the amount illegal manners. No, ni take. And I said the tips.
How can the land that you have a license to mine gold? You do illegal mining on the land that has been given to you to mine gold.
It is
illegal.
Yes, you can.
Yes.
The license is. It has a recommendation.
License and Mining Act, it's clear, absolutely clear. When a license is given you on a particular land, you need an operational permit within the legal frameworks of the mining process.
And even how you conduct the mining.
And how you conduct the mining. I'll give you a typical example.
Is that the issue?
No, but that's not the conversation on the table. That's not the conversation on the table. That's not the conversation on the table. It's true. That's not the conversation on the table. You cannot mine. It may be within your license, but you cannot go there. So you cannot say a license to you gives you a blank opportunity to own your insurance. It is not like that. Whether you allow or not, if you understand English, you understand. With all this, you bet me I try the viewer now.
It will be double jeopardy. Unless different facts. Unless it's different facts.
But the bogu and the ashare.
Yes.
But see to be shemwa and some phobia between Sunday and
yes, on different factors. But it's important. Again, Machania Man 9, the kind. On the comparing Wontumi to Maslock, no. Yes, there are similarities. Me Susu say the reliance on the person now acquire mining, no, the evidence of the person who is, in my view, Wontumi, then he's the real criminal,
the principal,
the principal criminal, no. Using him to get to Wontumi, it happens in criminal trials, but I think that the over reliance on his testimony is a real issue at appeal, but his lawyers will deal with that in appeal.
Which was not denied by Wontumi himself.
But having said that, having said that, I think the difference,
anyway, I think
the difference in Maslock is that there is real document of receipts and letters coming from Maslock asking for interest, and there's a real. I think no was say me say me the sikanema o ma me receipt. And I'm my minister one farm me now me try letter cry by Jays ebusa for scan money. It's a very different.
Is there as an evidence?
Yes,
but there's no receipt or messages for evidence. Which one would you have?
There's no messages, but there's a letter purporting.
So you see the money being sent to him.
And the point is that
you
yes,
want to meet the land to the people for
yes,
you saw them.
Yes.
There's a real
issue what issue
serious, of course.
I think so. So I think that difference you're very clear. In one part, there's actual doubt. Say Sikano Wahin. There's a legitimate question to answer. Sikano Wahin. But the reason why the claim and I say because investigators are in my view. To answer clearly, Sikano Wayne. The second part, in said that the regional directors, the question is, say Yeji Obiadan in Wontumi case, no, both of them were in court. Where Yanka say Wontumi because documentary evidence and yet the only evidence. There is oral evidence as well.
No, not in assignment.
No, I'm not talking about that.
Dealing with
I'm
land.
not talking about
dealing with
assignment.
land. Yes.
I'm not talking about assignment. Because to me, testamental evidence,
oh, yes.
it's allowed. So nothing stops that.
But
question is,
just a point of order. Testamentary evidence, who say, Kuma say no. So person transfer land.
I'm not talking about land. I'm talking about evidence as a block. You probably understand what I okay. Let me land properly.
All right.
The point I'm making is that in the Maslow case, nothing stops testamentary evidence. Nothing stopped you from calling the directors or Musi training numbers for them to testify in court. So that in the record, but relying on a third party to come and tell us is a flaw that should have been exploited. And then the last one, no, Eja. Politics many lawyer say I also think say we need to look at our judiciary critically. Obia Opegana Yebia, including those of us who are vested in the process,
I agree.
Should be very, 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 very interested in, because you see, the real question is, as practicing lawyers, but as practicing lawyers, justice has to be defined and predictable. I completely agree. Justice has to be not swift, but it has to be proceed in a way that it's not denied by the slowness of the process. Indeed, we need to look at judiciary in whole. But having said that, no, lawyer behind say Wontumi sebi mankind 94 pages I would have been doing a great disservice to everybody listening, because sebi asudie were so. And the politicians are part of the problem in why the judiciary seems the way it is. In Pembebreno, Obia Sona Fanfa, without necessarily listening to the reasoning of the court. Meaning, say, lawyer for me, no. The same person, and it's funny. Obako court, we know argue one side.
That's the beauty of
the other court, the same case now, the other court, Ujinafano. No, Ujinafa.
Yeah, professional.
Exactly. Exactly. So I agree, say. In judiciary, no, they are learned lawyers as well. Until they can reason ordinary, they can reason any decision they want out. But the point is, judiciary and the work to me so making decisions. To the extent that it's not deferring from the law, I think we should respect that. Okay. Because can polarize the system. Because the first time I can take one case and argue from both sides. Means say I also say case be about.
That's the beauty of the law.
Exactly. Into the first say yebenya fa no ye de tumi ma obi say on or what tumi so si jina na. We need the decency to respect that without reading the political undertone, because that increases the polarization of the
some time
ago. This is of the court. The presumption in law, they say, it's a key public policy. Public policy, yes. The Crawford dream. And Emran Kasa. It's in a way because we are 12-member jury and not 10 of them. No more here, you know. Omamnya lawyer for move street sooner. It's a judge, yeah. The judge behind.
Council, I disagree with you.
Oh, you can't because this is a fact. And it
of course, the jury is from the
distributed in law. And it's no judge behind who dear sema naturally no. Except public policy no. Account and send away dear sema. It's over share. The ecoso. Oba transfer the ecoso until if any headroom. Any Emran Kasa Emran so I outdated. Oba share Emran baby 20 year precedents no. The judges actually civil law jurisdictional they go back to the law all the time because sometimes the law has become obsolete. There is no law in place of it, so judges have to come up with precedents which other courts will follow.
Policies are not really.
Policies are not really. Also, problems of one who or may in some way the court to know.
That's why some people are convicted to serve.
The first problem is about how charge sheets are drafted. When the state charges someone with a crime, the charge sheet is supposed to say exactly what the person has done.
Of course,
the person did, the specific acts, the date, the amount, the transaction. What's happened in some of these cases is that charges were written in a genetic way, basically repeating the wording of the law with a name and a date attached, with nothing to show what was actually done differently from the charge sheet. In just say, I don't know. Just in I say yeah, auntie, yeah, they want to be date in the cafe. Can you date me? So for a shock. Can I say no? It's also can be now.
Yes, some of the charges are striking out.
Striking out.
The charges.
Even Hanan case, Hanan case,
Madam Masipa,